In progress.
Good morning, everyone.
He has like lights.
Good morning.
All right, guys, I'm hearing a lot of people, so I am going to mute everybody for as much as I love you all, so that we don't get a lot of background. Okay, Paul, if you want to unmute yourself, Matt. Where's Matt? Why don't I see Matt?
He's here.
There he is. Matt, I'm going to make you a host so that you can share your screen later.
Wow, it's like a promotion in front of all these people.
You are now the host and not me. How do you like that? All right. I think we're at 97 people, so pretty full.
Yeah, we can get started.
All right. Marley, did I see that you record this? It's already going. Was that you?
Hi, you recorded it when you started it.
Oh, well, look at me.
It says recording.
Awesome. That's what I wanted to know. Just remind me before we hang up to make sure I reclaim myself as the host, or else I'm going to have trouble getting that recording. All right, we are now at 100 participants, so we have hit the capacity. Just so you guys all know, we are recording this as I stated. So we are going to post it later on, where do we normally post it, Mar? Our Facebook page and our website?
On
Or
our
YouTube
YouTube,
channel?
which I also included on the link for, so everybody already has it and I can get it now.
The
Get what?
problem, Janelle, is the people that are on. It's the people that are off need to know that.
Yes, I know. Marley put it in the email, but also the people that are on may have colleagues that didn't get on, smartass. So, oh, look, it took me exactly 2 minutes to curse at Paul, guys. It might be some sort of a record. Okay, this is a big one today, guys. We're going to try and keep it to an hour, but we want to cover federal, PA, New Jersey, Philly. We're going to do New Jersey at the end, mainly because it has the most of what's going on right now and is going to be the longest. And that way, if anybody that is not in New Jersey wants to hop off at the end, we understand. Normally we would do Philly at the end. Usually that's longer. And while Philly is a pain, and there's a lot to talk about, I think Jersey takes the cake right now. So we're going to start with what's going on federally because that affects every jurisdiction. And then we'll move into PA because that's actually kind of mild. And then we'll move into Philly and then New Jersey. Okay. All right, cool. And listen, as always, unless you've never been on here before, throw your questions in the chat. I'm going to monitor the chat room. We'll try and get to them as we can, as best as we can. Like I said, we have a lot of information to cover, so I may not share as many questions as I normally do. But I'll try and do as best I can. And if for any reason I don't get to your question, just shoot Marley an email. She'll get it into the appropriate hands, whether it's me, Matt, Paul, or even my team. Just real quick, I'm going to introduce some of the people that have been busting their ass over the last year and a half, but especially the last 2 months. If you see them, they're together, wave girls, Amanda and April down there. Those girls are our Philly team. They have been dealing with rental assistance. We're going to get into a little bit more of that later, and they are unbelievable. I don't know how they're still sane after the last 6 months. So Amanda and April, our A team, you're amazing. Diane, where are you at, girl? Diane's Jersey. Her life's about to get very difficult. So while she has been kicking ass, she's going to really start kicking ass over the next few months. Anybody who's in New Jersey has to know Diane. She's our Jersey girl and she's fabulous. Jackie and Wendy, can you guys wave real quick? There they are. So Jackie has just recently got a promotion. She's assisting all the attorneys, but she is still helping in both New Jersey and in the districts in Pennsylvania. And Wendy heads up our districts in Pennsylvania team. So they have been dealing with this CDC order and how it's been a problem throughout the counties in Pennsylvania. It's been a little bit of a nightmare for the past year. So kudos to them. And then Sid, where are you at, Sid? There she is. She's in there with Caitlin. Are you in with Caitlin there? Yep, they're both amazing. So Sid came on early on as a receptionist, and now that didn't last very long. We had to promote her as well. Not had to, we're happy to promote her as well. She helps in Philly, she helps in Jersey, she helps in the district, she does it all. So she's kind of a catch-all. And Caitlin came in. She's now a receptionist, which in our office has never been a receptionist. So she helps with everything too. So we have an unbelievable team, all led by Marley, who, if you don't know Marley by now, I don't know how you're our client. I think she's dealt with every one of you, and she is the glue that keeps us all together. So I'm sorry for the little bit of a promotion, but part of that is so that you know who to reach out to if you do have questions I can't answer today. And part of that is because every one of these people have had one hell of a year and a half, and I just wanted to give them a little bit of accolades in front of our clients. So, all right, Paul, do you want to take away from a federal perspective?
Sure, just a quick disclaimer that we give on all these talks. Whatever we tell you today is only good for today, probably only good for this hour. As you know, everything changes extremely rapidly in this new world of COVID-19. In fact, while I was sitting here, I don't know if you guys saw this, but the CDC just came out with a new guideline regarding masks. And they're saying now, do not, this is very important, do not wear a Philadelphia Eagles mask because it doesn't provide any defense.
All right, I like that joke for once.
I was waiting for it.
Yeah, I saw you, Marla.
I like it.
Although I
And
think I
then,
want to switch that to Dallas Cowboys. I mean, come on.
It's all good.
All right, go ahead, Paul. Take it away.
Okay, on the federal level, so let's start with the CARES Act. Unfortunately, we're still dealing with that. Under the CARES Act, there was a required 30-day notice that needed to go out before you could file for an eviction case. It only covers situations where you have a quote unquote covered property. I'm not going to get into all the details of that. We did that in many other seminars. You can go back and look at that if you guys aren't familiar with that. It's kind of old news, but the new news is that we all thought that the CARES Act notice period ended. However, there was recent guidance by the government that said that you still have to follow that 30-day notice. Now, if you talk to attorneys like ourselves and attorneys throughout the country, they will all tell you that they do not believe that that's the law, that you still aren't, that you aren't required anymore to give that 30-day notice. However, the government is saying that you do. So out of an abundance of caution, we're recommending to everyone that if you have a CARES Act property, covered property, that before you start an eviction case, you send that 30-day notice or have us do that for you. That's the CARES Act. Next thing that's going on, as I'm sure you're all reading about, is the CDC moratorium. Very, very, very confusing. I'll try to explain it in the simplest way I can, but it's going to be difficult because it's a little complicated. So as you know, the CDC moratorium was extended until October the 3rd. The original CDC, or I shouldn't say the original one because it's been extended quite a few times, but the CDC moratorium that was in effect prior to this new extension ended at the end of July. There was a case that was filed against the CDC prior to that time where they challenged whether or not the CDC moratorium was constitutional. The judge in the federal court case said that the CDC moratorium is unconstitutional and should not be in existence. So at that point, the CDC moratorium went away. However, the CDC took an appeal of that decision, and in that appeal, they asked the court for a stay. And when you ask the court for a stay, what they're doing is they're saying to the court, until it gets decided by a higher court and ultimately by the Supreme Court, let's keep the status quo. That stay was granted. So in effect, at that point in time, the CDC moratorium stayed in existence. The case worked its way up to the Supreme Court. And here's where it gets really confusing. The Supreme Court, in its decision, had 4 justices say it was unconstitutional. 4 justices say it was constitutional. So you sort of had a split. Judge Kavanaugh was the deciding vote. Judge Kavanaugh said, here's what I'm going to do. In his infinite wisdom, he said, I'm going to side with the 4 justices that are saying it's constitutional, meaning it should stay in effect. But he said, the only reason I'm doing that is because there's only 2 weeks left. This was in the middle of July. He said, there's only 2 weeks left. The moratorium is going to end in 2 weeks. This will give additional time for people to get rental assistance. And he said in his, what they call a concurring opinion, he said, however, I'm telling you, didn't say it in his words, but essentially this is what he said. I'm telling you, it's unconstitutional. It should be stricken. And the only way it should stay in effect past the end of July is if Congress decides that it should stay in effect. The president then said, this was in July, I don't have any power based on Judge Kavanaugh's concurring opinion. I don't have any power to extend the eviction moratorium. Congress needs to do that. Congress had an opportunity to do it. Congress failed to do that. So at the end of July, the CDC moratorium ended. Then what happened was the president decided, as I guess you all know, that he was going to tweak the moratorium a little bit to try to make it constitutional, even though he said in his press conference that he knew it wasn't constitutional. He spoke to constitutional scholars. They all agreed, other than 3, that it's unconstitutional. Yet he knew that if he extended it, by the time it worked its way through the courts, it would take weeks and possibly months. And therefore, he was hoping that people would be able to get the additional rental assistance. So he went ahead and had the CDC extend the moratorium through October the 3rd. The attorneys that had filed the lawsuit against the CDC that went to the Supreme Court, where Judge Kavanaugh issued the concurring opinion, then went ahead and challenged this new CDC extension. The case has been briefed. It was argued, and the judge said that basically the government is doing, in her words, gamesmanship in what they're trying to do. She seemed to indicate at the oral argument that the new CDC order was unconstitutional, but here's the rub. She said that the actual majority opinion, even though it was only 4 justices that gave that opinion, said it is constitutional. So even though Judge Kavanaugh, who was the deciding swing vote, wrote a concurring opinion saying it's unconstitutional, he's actually sided with the side that said it's constitutional. So the problem that she has in trying to decide this case is the actual precedential law says it's constitutional, even though we all know if it goes back to the Supreme Court, which it's going to do, that Judge Kavanaugh is now going to side with the other 4 justices and say it's unconstitutional because he told them specifically in his concurring opinion that he thought it was unconstitutional. So that's where we're at right now. The judge in the federal court said, I'm going to give a decision. This is her own words, in the near future. I love that. What does in the near future mean? I was hoping that we'd actually have a decision by today. Unfortunately, we don't. So the near decision is not too near future. It's not 2 days, according to her. But we should have a decision any day now. The problem's going to be is the government's going to then ask for a stay. And the question is going to be whether or not the court grants that stay to allow the law to stay in effect till it gets to the Supreme Court, till the 5 justices can overturn the decision. If I had a bet, although I think I gave up betting on what's happening with the CDC.
You'd be a very poor man.
But I would say that the Supreme Court is going to say it's unconstitutional. The real dilemma issue that we're faced with is how long is it going to take for that to happen? And until it does, the CDC moratorium is in effect.
Now here's
And
where it gets really confusing. Where is it in effect, Paul?
Yeah, so that's a great question. And it's basically in effect in about 80% of the country. It depends what the levels of infection are, and that can change. And if you reach those levels, it'll be in effect for at least 14 days till you get below those levels. The bottom line, as far as that goes, is it's pretty much everywhere.
We actually,
I'm not-
well, I was gonna say, Jackie just dealt with this. The levels were low. Jack, where you're at? Can you explain what happened? Because this is kind of funny, guys.
So what happened was that after this new moratorium came out, we mailed out our order for possessions to get lockouts. In Lehigh County, the court processed it because they were at a moderate level of COVID. So they posted it on the door, and then they called us and said, hey, we're now at substantial. We can't do these lockouts anymore. So there's really, I mean, it's changing on a daily basis. And I just pulled up like the COVID county tracker. And last week, there were some counties that were in low and moderate. Well, now they're in substantial. And as you know, in the districts, like we get lockouts usually within 2 weeks from once our office processes them through the courts. So we just don't even know what's going on with lockouts, because one day it's going to be moderate, the next it's going to be substantial, and we're just going to have to keep on filing every week and crossing our fingers.
The short answer to all that is I would just assume it's going to apply to every county, and we just have to wait till this works its way through the courts. I can't see any court allowing us to do that. They will find, as they have been all along, any way, any excuse to say that they're not able to allow us to file. And that's pretty much what's going to happen. So you can determine that they're not in the substantial. The county can, or we can decide that, but they're going to figure out a way to say that they are in the substantial. And
Now,
especially the way
remember, this only applies to people who have filed or given you a CDC affidavit. Okay, that piece of it still remains and is in existence. So we are still doing lockouts, and Jackie's still doing Jackie and Sid are processing our orders for possession. And as long as the tenant doesn't provide the CDC affidavit, we should be able to do the lockout. Now, I use the word should because there are some judges that have interpreted the CDC order to state that it applies to every tenant, and that we just can't get through to those judges. But they have to provide that affidavit. I mean, that's what the CDC order states, and that's what the new order states as well. So this is only applicable to those tenants who have provided those orders.
Okay, that's my federal report, Madam
Okay.
Chairwoman.
Madam Chairwoman, that's great. Okay, on to Pennsylvania. So when I talk about Pennsylvania, I'm talking about it as a whole, but I'm mainly talking about the counties other than Philadelphia, because Philadelphia, which Paul's going to come back on and give his second report on soon, is a whole different ballgame. So in the counties in Pennsylvania, basically all we're dealing with are two different things: the CDC moratorium, and then we're dealing with rental assistance, which Marley is texting me on the side here saying, don't forget to talk about rental assistance in the counties. So rental assistance in the counties, when that applies, when a tenant, basically what I'm experiencing and everywhere but Bucks County, and I'll explain Bucks County in a moment because that's a whole different ballgame with an opinion that just came down the pike last week or 2 weeks ago. I don't even know. Time's starting to all meld together. But there's rental assistance, obviously, throughout the entire country. In Pennsylvania, basically, other than in Philadelphia or Bucks County, there is no rule or law that states you can't go forward with the eviction. What we're finding is that courts are mentioning it to the tenants as they come in. So if a tenant doesn't show, we get a default judgment, we move forward, no big deal. The tenant comes to court, the judges, the clerks, sometimes it's in with their paperwork, let them know about rental assistance, and then they give the tenants an opportunity to go ahead and apply for that rental assistance, which in the end is a great thing for you. If all it is a money issue, you want that to happen. So sometimes the courts give us the judgment, but give the information on the rental assistance. I've had that happen. Sometimes the judges continue the case, the tenant can get rental assistance. It all just depends. In Bucks County, they put out, the president judge put out something that stated, an order that stated that BARA, which is who is the rental assistance in Bucks County, if a tenant has applied for BARA and can show they applied, that the judge can continue the case 30 days or sometimes 60 days if the 30 days isn't enough to allow the tenant to get rental assistance. That order was just upheld by the Pennsylvania Supreme Court a week or two ago. So in Bucks County, basically what's happening, and I know I had a couple cases, I don't know if there's people on it down in Levittown for one of our clients. They are basically you get in a court if the tenant had the paperwork saying they applied for BARA, the court just continues the case out 30 days. Actually, the judge in Levittown continued them out 60 days because he was retiring in 45 days. And he's like, I don't want to deal with this. Leave it for the next judge. And he just continued it 60 days because he does have that option under this new order. So again, though, at the end of the day, if they are applying, and Jackie could probably speak to this a little more, Bucks County, Montgomery County, they've been pretty good with regard to rental assistance. Yeah, she's shaking her head yes. So it's actually a good thing. You know, it means if they've already applied, you're likely to get your money through BARA or through the Montgomery County rental assistance. So it's actually one piece of this that seems to make sense to me. Okay, so Melissa Small is asking, are the courts allowing us?
What?
Go ahead.
You go.
Someone was asking a question. So go ahead.
That me?
Yeah, you go, and then I'll do the
I just
question.
Okay, sorry. I just wanted to say that Bucks County was the first county to try this. And when I say try this, is what Janelle was just explaining, where they issued an order saying that the judge could continue the case for 60 days while the tenant asked for rental assistance. That, in my opinion, should not have been upheld by the Supreme Court. I don't believe that the court had the authority to do that. I could spend another half an hour explaining all the reasons why, but suffice it to say, because it doesn't really matter what I think, it matters what the Supreme Court of Pennsylvania thinks, and they said it was constitutional and allowed. The concern that we have now is that now that Bucks County has done that and it was just approved by the Supreme Court, I would bet that there's going to be many other counties that have seen this and are saying, hey, if they're doing this in Bucks County, why aren't we doing it? It's been held to be constitutional. Supreme Court's affirmed it. We should be doing that as well. So I'm guessing you're going to start seeing that in a lot of counties over the next week, month, that they're going to say the same thing, that if the person's applied for the rental assistance, that you can't go ahead and proceed with your court case. The problem is, and you know, as Janelle said, it's a great thing if you can get the money. The problem's going to be this money isn't going to last forever. This money is going to run out. So what happens if they continue the case for 60 days and there's no money? You know, you're just out in another 60 days worth of money. It's great if they can get the rental assistance. That's wonderful. But what if they can't? And that's the biggest problem with this. If they would guarantee and they said, okay, we're going to continue this case for 60 days so they can get rental assistance and say, and we're guaranteeing, Mr. Landlord, that you're going to get your money, I'm okay with that.
And what about Mrs. Landlord?
Yeah, there you go. When they're not, it landlord, when they're not guaranteeing that, or at least saying, hey, we're going to guarantee that you'll get the money for the 60 days of the continuance, because you're now out an additional 60 days of rent. Where's that? You know, come along and say that, I'm okay with it. Without that, I think it's ridiculous. But
so what I was doing
to me.
I've been in court lately. It's been a little crazy. And what I've been doing is ask for only 30 days. I keep telling the judge, hey, they've already applied, shouldn't be longer than 30 days. So that in case that happens. Now, the one where the judge was retiring, there was no arguing with him. But for the most part, the judges have been good about only doing 30 days.
Yeah, but you know, if they're still trying to get the assistance, the judge is going to give them another 30 days to get it.
Agreed. But at this point, at least if the money runs out in that 30 days, then I can make that argument when we go back in 30 days. So if we can just keep doing the 30-day increments rather than 60, where the money could run out on day 15, especially as we get further and further along. Right now, it's not a big deal. 60 is not the end of the world because it's likely not going to run out in the next 30 to 45. But a month from now, 2 months from now, 60 days might be way worse, you know? So hopefully the judges will keep listening and only do it at 30 days. Okay, so Melissa Small actually had a really good question. Are courts allowing us to challenge the CDC affidavits based on failure to apply for rental assistance? Matt, do you want to speak to that? Because I know you've had a lot of these veracity hearings and kind of explain how that works.
Wait a minute. Before you get to that, Melissa had a good question. That's amazing.
Stop Stop that. Listen, I will knock him upside the head for you next time I see him.
Sorry,
So
I couldn't help myself.
on the veracity hearings, certain judges, largely the same judges that Janelle and Paul were talking about, that Jackie has been dealing with, that won't lock anybody out. Those same judges are not allowing us to have veracity hearings. The majority of judges are allowing us to have veracity hearings. So basically what happens is we go to court, the tenant enters or submits their CDC declaration. We consult with you as the client and say, do you have any reason to believe any of these bullet points are incorrect? So, I mean, there are 4 or 5 bullet points. The first one is applying for rental assistance. However, there's another one that I've been successful getting them thrown out on, which is I've made my best efforts to make payments as close to the regular payments. So one of my favorite questions to ask the tenants is, so you're telling me in the last 12 months, you haven't had $1 to pay towards the place that you live? I mean, obviously I'm trying to make a point, but we've been pretty successful with that. So we can request that hearing. Our office sends a letter, request the hearing, and usually within a week or 2, we get a veracity hearing. And if we can get the CDC declaration thrown out, then we can proceed with the lockout.
Awesome. Thanks, Matt. And then someone else asked the
And,
CDC.
just for the record, Melissa is an attorney. She's great. I was only kidding.
She wrote, haha, it's okay. She knows you're kidding.
Yeah, and in all this, Melissa and I talk all the time, and she's one of the few people that are totally on top of what's going on with this stuff.
All right, a couple of people actually asked, the CDC affidavit only needs to go to the property, correct? Does them sending us the affidavit mean we cannot file, or just that they cannot be locked out? Okay, that's actually a wonderful question. Yes, it only needs to go to the property or us or the court. They've been handing them to whomever. If one gets handed into somebody, then it counts, is the short answer. And then the second part of your question is, the CDC has put out frequently asked questions that states it should not stop the actual proceeding from going forward. We should be able to get a judgment. It's only supposed to be stopping the lockout. However, it depends on the judge. We have some judges that won't let us file. We have some judges let us file, but they continue the hearing. We have most judges are letting us proceed to get the judgment, just not allowing us to do the lockout. But it's going judge by judge, and it's just, there's too many differences for us to keep trying to go over these judges' heads and challenge them with the president judge, because at the end of the day, you're not getting the lockout anyway, so it really doesn't matter, you know? And that leads us to another problem that we are having that Jackie brought to my attention last week. When the CDC affidavit expired, or the moratorium, expired, and we had a couple of days there before the new one went into effect, the court started calling us to do the lockouts. So we started calling us to do this, to schedule the hearings on the ones where they weren't letting us schedule. And then we started to try and do the lockouts. Jackie started sending orders for possession in on judgments that we received starting last August in the counties in Pennsylvania. The court started telling us that the problem is that a judgment is only good for so many days. We are past that deadline, okay? And so therefore they're saying that you can't file an order for possession because it's been past the deadline. Paul did some research to see if there was anything that told that 180 days. And the problem is there's not in Pennsylvania.
In Philadelphia, there is, but not in Pennsylvania.
Correct. So the problem is that, so in Philadelphia, you can file a motion to extend the 180 days. There's no mechanism for that in the district courts. You can't file a motion in district court. Okay. You basically can file criminal, civil statements of claim, and landlord tenant cases. That's about it. Truancy. They don't have, it's not a motions court. You can't file a motion. So Jackie actually came up with a really good idea, which we haven't had a chance to test yet. I don't believe. I think we're going to try and test that. Well, we can't test anything until the moratorium is lifted by the courts, but she had a situation in a completely different case, in a completely different situation, non-dealing with COVID, where she reinstated the judgment, and we were able to proceed with that reinstated judgment. So she is going to attempt to do that on all of these cases once the moratorium is once again lifted. She's going to reinstate the judgment so that we can then have a fresh judgment to be able to file the order for possession on. Okay. If that doesn't work, it's not like you're not going to be able to lock them out. We are just going to have to refile a new complaint based on for possession, either for the ongoing monies that they still haven't paid since the last judgment, because I'm sure that exists, or, and this is kind of complicated, you can file a complaint for possession only based on the monies, based on non-payment. So we will go that avenue and that route if we have to. But our hope is that reinstating these judgments in the courts will allow us to proceed with the orders for possession once we can once again go ahead and do that. So stay tuned for that. It's another new little snag. Maybe once this second moratorium is lifted, the courts will understand that, get smart, and be some type of an order that is passed out. But we'll see. And I think that brings us to the end of federal and Pennsylvania. Okay, so we're going to move into Philadelphia next, and then we're going to move into New Jersey. All right, Paul, you want to, as succinct as possible, sum up what the heck is going on in Philly right now? And I think Amanda and April might jump in here with some of the logistics at some point.
All right, I will try. So the first thing that you need to do in Philadelphia before you can file for an eviction action is send out the notification of rights to the tenants. And that's under the Emergency Housing Protection Act that was passed last year. So you basically are informing the tenant of all the rights that they have in Philadelphia. The next thing that you have to do is file for rental assistance. And this is on non-payment of rent cases. You have to file for rental assistance before you can file a landlord and tenant case. From the date that you file for the rental assistance, you have to wait 45 days until you can file the complaint. Additionally, you have to file for mediation. Still not 100% sure if it's mediation or rental assistance. The law isn't real clear on that. When you file for rental assistance, they were supposed to automatically enroll you in mediation. They didn't do that initially. Then they did it. Now they're not doing it again. So we're not really sure on what's going on with that. The bottom line, however, is that once you apply for the rental assistance, it's often good to go to mediation because you get a mediation counselor involved in it that can help you with getting the rental assistance. When I say help you to be able to get to the tenant and get all the information from the tenant so that they complete the proper application or give us authority to go ahead and do the application on their behalf. I just want to quickly talk about rental assistance because this is going to be a disaster in the making if it hasn't been already. See, April's laughing. Yeah. An additional disaster. So just real quick, give you the numbers. You don't need to know the numbers, but I'm going to go through them with you so that it makes sense, and then you'll see where I'm going with this. There have been approximately 45,000 applications for rental assistance in the city of Philadelphia. 37% of those applications have been marked as incomplete. They don't have all the information to be able to proceed. That leaves 63% as complete, or 28,500 applications. I'll show you why that number matters. There was $135 million that's been appropriated to the city, which sounds like a lot of money. The city has already spent $70 million, which is approximately 55% of that money. The 55% comes to, I guess, 22,250 people, applications that haven't been reviewed yet. On August the 9th, as of August 9th, that was Monday, the city had given out approximately money for 9,100 people of those applications. Additional 1,000 have been approved to get the money. Where am I going with all this? Get to the bottom line of it is that when you look at all these numbers and how much is available, since the city has already given out 55% of the money, they only have 45% left. That when you do the math, you will see that of the applications that have already been submitted, 26,000 of those applications will not get paid. So of the 45,000 that has been submitted, approximately 26,000 will not get any money. In addition, there's people that are still applying, and they're applying and saying, hey, you can't file for an eviction until you apply for rental assistance. Do you think there could be any money for those people?
Crazy.
Yeah, sorry, my Alexa just went off. This is insane. With Alexa and all the stuff in my ear, she's talking to me. It's like, what did I say?
I don't know
that?
what you were doing. You're like,
I
stand out
said
this
Alexa. I'm
space.
like, who's talking to me? Sorry. Anyway, so the bottom line of it is that there's going to be a lot of people that apply for rental assistance that aren't going to get paid. This is a problem. The city is reviewing right now. And by the way, a lot of people are knocking the city. I personally believe the city's doing an unbelievable job with what they have. Usually, people say the city doesn't do this, city doesn't do this. Greg Heller's doing a great job. City's doing an unbelievable job with what they have to work with. It's not easy to process the number of applications that they have, especially in this climate where it's so hard, as you all know, to get employees to work. City is short staffed. They're having a hard time staffing the people. They're trying to get their computer systems. It's just a nightmare that they're going through. And to be able to process 3,500 cases, imagine that, 3,500 cases per week is amazing that they're able to do that.
Paul and I went to a symposium down in Georgia a couple of weeks ago before the numbers were insane. And with attorneys who do what we do all over the whole country. And a lot of what we were talking about, obviously, was all of this. And New York, the state of New York, as of 2-3 weeks ago when we went, I guess it's been 3 weeks now, had not cut a single rental assistance check, not one. I was in shock when I heard it. So I agree. I mean, for as much as Philadelphia is driving us crazy in so many ways, and we're going to touch on a few of those ways here in a second, this is actually one thing they've been doing pretty decently for the size of the city. Yeah.
So the bottom line of it is there's a lot of people that have applied that are not going to get the rental assistance, and this is a problem, and you're not going to be able to file still for the 45 days. Hopefully,
yeah. So I'm sorry, go ahead.
Yeah, I was just going to say, hopefully the city will realize that, and that once they realize you're not getting the rental assistance, will allow you to file. I'm guessing they're going to realize it, but do exactly what the president did with the CDC and say, oh, you know what? This is still a way for us to delay the evictions for another 45 days. They're going to keep it in place anyway.
Either that or they'll go back to diversion, which is 30 more days anyway. So one or the other is going to sit in place. I mean, I don't think the diversionary program is going anywhere ever. Forever.
Yeah, but just keep in mind the purpose of the diversion or mediation was to allow the tenants to get the rental assistance. The idea was to bring them before a housing counselor, bring the landlord and tenant together, get them to apply for the rental assistance and get them the money. So I think you're right that they want this mediation or a diversion to last forever, puts another delay in it, but without the ability to get the money, it's a total waste of time.
Yes, but they also they also make toll roads to, fund a bridge. And then when the bridge is already built, the tolls don't go anywhere. So somehow they figure out a way to do stuff like that. Okay. A couple of logistics while we're talking about, well, before we even get to that, we just found out this week, I believe it was this week, with regard to writs of possession and alias writs of possession, a new order just came down. Do you want to touch on that quick?
Yeah. So any writ that was filed before May the 1st of this year is going to have to be reserved before we're going to be able to file the alias writ. So what normally happens when you file writ of possession, it tells the tenant that they have so many days within which to get their stuff out of there and move out, because they're going to be locked out after that, but doesn't give them an actual date of the lockout. Because you haven't been able to lock out tenants, that could be months. Could have happened months ago that notice was actually sent to the tenant. And then the fear that the court had was that all of a sudden, the sheriff's going to come and say, hey, you're being locked out now without any warning. So they wanted to build something in there to allow the tenants to get that additional notice. So any writ that you filed in Philadelphia prior to May the 1st is going to have to be reserved. So it's going to be
In
another
addition to that,
fee.
if they, go ahead.
Yeah, they're going to charge another fee and have that new service go out.
And if they have applied for rental assistance, there's a piece to it too, right?
Yes. So with regard to alias writs of possessions and doing the actual lockout, the court has said that if the rental assistance application is marked complete, then you're not going to be able to go ahead and do the lockout. So it begs the question, what does complete mean? Does that mean approved? Don't know. The language that they used was complete. That's the word that they use. So if you have a completed application, then you can't proceed with the lockout. As we know, based on what I told you before in the statistics, even if you have a completed or approved application, that doesn't mean there's going to be enough money. There is today if you have that, but in 2 weeks, 3 weeks, 4 weeks from now, there probably isn't going to be. So even if you have an application marked approved, what if there's no money? So these are things that we're going to take up with the court and try to get straightened out, because this is a real problem. The other problem is, what is the definition of complete? Doesn't necessarily mean approved. So I look at it and say, okay, complete is the opposite of incomplete, right? At least you would think. Okay. We know what incomplete is because we get notice that says your application is incomplete. There we have it. So if we haven't gotten the notice that it's incomplete, is it safe to assume that it's complete? So we don't want to assume that, because we want to be able to proceed. But I can guarantee you that if I could think of this, you can be sure that other attorneys that represent tenants are going to think of this, and they're going to say it hasn't been marked incomplete, therefore it's complete, therefore you can't proceed. It's insane. The law then says that 90 days after you get rental assistance, assuming you do get the rental assistance, you can proceed with the lockout. Well, in that order, it says that after 90 days that you got the money, you can go ahead and proceed. What if you never get the money? Then based on that order, and if you read the language of it, you can never proceed. So these are things that we're going to have to work through. But for your purposes, and what you need to know for right now is that basically, if they have an application that's out there that hasn't been marked incomplete, you most likely will not be able to do the lockout for at least 90 days.
So like you said, we're going to try and kind of parse all this out. Someone asked a question, their resident owes about 25 grand. You're supposed to get locked out back in March of 2020. Do I have to refile on them? No. I mean, you're probably gonna have to file a motion to extend the 180-day time period. But I mean, technically you should be able to proceed, but I don't know now with all the rental assistance, you might have to go through all of these hoops first. So with this new order with regard to writs and aliases. So
yeah, what you're gonna want to do in that case is file a motion to extend the 180-day rule. Don't have time now to go through all the details of explaining that to you, but suffice it to say that if you have a case that's from that old, from before March of 2020, you want to immediate look at extending the 180-day rule so that you'll be able to go ahead and file the written alias writ of possession. If you wait till the 180 days expires, the court has told us that they will not grant those petitions. You want to file that petition before that 180-day runs. All right. And the last thing I want to say is that with regard to landlord-tenant appeals, as of August the 2nd, they have stayed or stopped or not allowed you to continue with your landlord-tenant appeals. They are now requiring that you first go to a status conference, and they're scheduling those status conferences. So any appeal that you have with a court date, they're all being stayed, and now you have to go to basically a diversion program through the common police court.
Insanity. After you probably already went through one at the lower court. It's insane. All right. Marley wants to talk on a few things that's been happening in our office with regard to rental assistance. We are running out of time, and Matt has to do his whole presentation. Marley, you got 5 minutes. Tops.
Just a few things with all these gray areas and literally court clerks calling us, asking us what's going on. And we're trying to reach out to you. This is how our office is navigating through this in regards to at least what's happening in Philly right now. This week, you should be receiving emails from Amanda and April. They will be asking you if you're ready to file, because the 45 days is up. If you're ready to file on tenants, we can finally file on a huge bulk of tenants that the 45 days has surpassed since the date that the application was made for phase 4. With that, we're starting with only the drafts, not the completed, incompleted, because of this gray area of what that is. So we're going to start with those and then ask you about the ones that the app is pending, essentially. With that, there is annoyingly more paperwork that we need for Philadelphia in order to be able to file. So we will be emailing that with you. And it is extremely important if you email us back everything at one time. Please keep in mind how many emails we are receiving for all of the different things that's going on in Philadelphia right now. So please, if you can just email us back everything we need in one email. Everything we need for the filings will be broken down in the email. It's basically, if you've ever filed in Philadelphia before, which everybody has, it's the normal forms. Plus there's an additional form about rental assistance. So if you did rental assistance on your own and we did not handle it for you, keep in mind we're handling probably at least 500 of your applications. So we'll be able to do that for you. But if you did it on your own, you do need to fill this out in order to hand it back. If you have any questions at all, we are available at all times. We're talking to tenants all day long and helping them navigate through this. And if you need anything, let us know. Please know that Philly court dates are so far out. When we have them, we will send them to you. We wish they were sooner. They are extremely far out. Janelle is talking about district cases are being continued left and right. Please know it's not us. We are simply receiving these calls most of the time and begging the courts for quicker dates to get you guys help for these residents. But I will put our YouTube in the page here and my email in the chat, Amanda and April, for everything Philly related. Bear with us through all this. We're navigating it. I think their girls are doing an amazing job. So if you have any questions, just let us know. And I guess, Matt, you can take on Jersey, and anybody that's not doesn't need to know about New Jersey. I think, Janelle, can they hop off if they want? The rest will be New Jersey.
Yeah, hold on 1 second. Let me just make sure. Lux, did we talk about what you wanted us to talk about?
Yeah, I just wanted to talk about the reissuing of the writs.
Okay, and that Paul touched on that, yes?
Yep.
Okay. All right, one quick question. If we did not file on our own, will you fill out the phase 4 questionnaire on our behalf? If it's one of ours, Marley, we do that for them, yes?
I actually just answered him privately. Yeah, we will fill that out for you, Tristan.
Oh, all right. Thank you, Lux. I appreciate it. All right. So I know that Philly's a little confusing. See these two wonderful ladies here, Amanda and April. You have any more questions, reach out to them. I'm sure you've already been dealing with them and they can help you with any other Philly questions you have. Amanda just put her, and April did, Marley just put everybody's email address into the chat if you need it. All right, Matt. Did you figure out that you can share your screen? Are you good?
I think so, yes.
All right, we're on to New Jersey, everybody. Matt's going to take it away. She put the link up for anybody who wants to hop off, who needs to share it. And all Jersey people, please stay on because this Jersey's insane.
Okay, so let's start with word association. I'll say the word, exciting. You're probably all thinking landlord-tenant law in New Jersey right now. So I'm going to go over the new stuff with you. Here is I'm trying to make it a little more interesting because, nobody likes to be the bearer of bad news. So let me try the screen sharing thing. Okay. Janelle, can you see the screen?
I can see it.
Okay. Cohen Marraccini, that's the name of our office. So if that doesn't look familiar to you, you can log off at this point. Current state of landlord-tenant law in New Jersey, otherwise known as, how could it possibly get any worse? On August 4th, Governor Murphy signed into law PL 2021, Chapter 188. This was sitting on his desk for a couple of months. It had been passed by the New Jersey legislature and it had been sitting on his desk the scuttlebutt on that was the reason he did not sign it sooner was because DCA, Department of Community Affairs, was looking for additional time to get their processes figured out before they were going to be inundated with all of these applications for rental assistance and certifications, which we're going to talk about in a second. So there's good news and bad news, as is often the case. Good news is that eviction cases based on any grounds other than non-payment or habitual late payment or failure to accept a reasonable rent increase, hopefully they're going to be, hopefully they're going to be scheduled in the near future. So prior to this law being signed by the governor, September 1st had been sort of the judiciary's default date to start trials after September 1st. There was no word. I've talked to a couple of judges and some court staff people in various counties. There has not been any update on that as to whether or not maybe the date's going to be accelerated, but I mean, it's already almost the middle of August. So I don't think it's likely that we're going to be getting any trials before September 1st. But they will be scheduling cases that are breach cases, not the non-payment cases, but the breach cases after September 1st. So the moratorium effectively ended on August 4th for these breach cases. Other good news is ejectments and commercial cases are up and running with no moratoriums. So if you've got a commercial tenancy or an ejectment meaning you've got someone squatting in the place, they never had a lease, they never paid rent, there was never a landlord-tenant relationship, that's an ejectment. That's done a different way. It's not done by a normal landlord-tenant complaint. We do these ejectments, so if you have any of those cases, let us know. So there's more, and it's that was the good news, by the way, in case anyone was wondering. So the eviction moratorium ends on August 31st for tenants who submit a self-certification online. That's the link, indicating that they earn less than 120% of the area median income. So the area median income is generated by HUD, and it is regional. So whatever the income for your region, area median income, 120% of that. If they fill out the certification as to their income and it's 120% or less, then they're covered until August 31st. Now, December 31st is the expiration date for anyone who's making less than 80% of the area median income. So this one is a little bit more complicated. I mean, you know, they have to certify to 3 things instead of 1. They have to certify they earn less than 80% of AMI. They have to certify that the non-payment is due in some way, anyway, to COVID. So I was in a meeting about this. The judiciary made it clear that, I mean, they were making some ridiculous examples like, you know, you couldn't work for 2 weeks because of your job, and during that 2 weeks you caught a cold and you had to buy cold medicine, and that cold medicine was the reason you couldn't pay your rent, then that counts. So, I mean, it's going to be a very liberal bar. And also they have to certify that they've applied for some kind of rental assistance. If they fill this out, then they're going to be covered until December 31st, no lockout until December 31st. So this is sort of the crux of this new law. So 120% or less, if they self-certify their income, then the non-payment of rent for the period from March 2020 to April 31st, 2021 cannot be the basis for eviction. So we cannot file to evict somebody for non-payment of rent for that period. If they earn less than 80% and submit that self-certification that we just talked about, September through December is also included in this can't be the basis for eviction period. So somebody earning less than 80% and fills out the certification, we can't file on them for non-payment unless it's from before March 2020 or after December 2021. If there's a pending case, the court will dismiss it once they get word from either the tenant or from the Department of Community Affairs that the certification has been submitted. We can sue them for the money. So I don't know how much of it you're going to get, but we can sue them for the money in special civil part. Special civil part is sort of like small claims in New Jersey, and it's usually got a cap of $3,000 unless you're seeking a security deposit return, in which case the cap is $5,000. So part of the new law has eliminated the cap on special civil part. So this is good because these complaints are much easier and faster to file. There's no discovery. You can't ask for a jury trial. It's if you are suing a tenant for $25,000 in back rent, it'll be treated the same way as if you were suing them for $100 in back rent. So this is a positive in that we'll get to stuff faster. So the online tool at that link that I showed you allows the form to be sent directly to the court. You can, if you're a tenant, you can enter the docket number, and they'll put that on the email that they're sending to the court so that the court will unilaterally dismiss the complaint. These two bullet points I copied and pasted from the DCA site. So as you can see, they're sort of addressed at tenants with the, the court will notify you separately when your form is processed. So this is sort of the way DCA is explaining it for the tenants, just to give you an idea of what they're seeing. So the tenant has not completed the DCA self-certification, but they can present other documentation at court to show they're in the midst of making the efforts. Then they can request an adjournment, and the court can adjourn the case up to 60 days. So tenant shows up, they're going to hold their phone up and say, Judge, look, right here's the website. I just submitted my application. They can ask for an adjournment of up to 60 days. Courts have been encouraged, sort of directed, to grant these requests liberally. So don't be surprised if some of these requests are granted day of. What if you think the tenant might be fibbing? When I was making this PowerPoint, I was trying to think of a tactful way to say this. So fibbing, I think, is it.
I think Pinocchio sells it, though. I love it.
Yes. So much like in Pennsylvania, we can request a hearing for testing the veracity of their certification. Now, much like Pennsylvania, or much like in the normal course of things, New Jersey is more complicated than Pennsylvania. So here in New Jersey, we'd have to file a motion with the court to challenge the veracity of the statements. This is brand new information, so it's not something we or anyone else has done before, but it's certainly something we can do to get it in front of a judge. And my argument at the veracity hearings has been that you only need one of the 5 or 6 bullet points to be inaccurate in order for the veracity of the declaration to be thrown out. So I've been treating it as it's the tenant's burden, because we can't prove a negative. So we can't prove that somebody didn't do something. They have to prove that they did. So in these hearings, I usually try to shift the burden onto the tenant to demonstrate that their statements are accurate. In case you're wondering, money owed from prior to the covered period, I kind of talked about this earlier. They can be grounds for eviction, but the moratorium on lockout still applies. So if you've got somebody that you filed on in March of 2020, you can still continue with that complaint. You're not going to be able to amend it to include all the new rent, but you can get a judgment for possession based on that rent that was due before the covered period, but you still can't lock them out until their particular moratorium period expires, assuming that they've filled out a declaration. Mandatory settlement conferences coming soon, or they've started already. If the tenant has not submitted a self-certification, the court will schedule a mandatory settlement conference. That's when I appear and the tenant appears and there's a mediator and we try to work it out. So if an agreement can be reached, the court will put the terms on the record and it'll enter as a regular consent to stay. If an agreement can't be reached, the matter is scheduled for trial. And as we said before, the trials are going to be sometime after September 1st. If the tenant doesn't appear, I've done these in 5 or 6 different counties. They're handling them different ways. So option 1, the judge says, oh, the tenant's not here. I know this is mandatory, but I really don't care. I'm going to adjourn this and reschedule it so the tenant can not show up the next time, essentially. Number 2, the court will mark it as a default and then say that they're going to reach out to our office to set up a proof hearing. A proof hearing is, in these non-payment cases, is going to be about 3 minutes. The landlord gets on with the lease and the ledger. They testify that this is the lease for this tenant. They testify this is how much the rent is, and they testify the current balance is X. So that's option 2. Option 3, I've had one court that says, okay, let's have a proof hearing right now. And so that's why we ask for the property managers to be on call. DI has been asking the property managers to be sort of on call so that if we get to this point and the judge says, counsel, I'm ready to enter this right now, I can call you and say, hey, log into this, make sure you have the lease and ledger so we can get it through. The last option is the court marks it as default. This was in one county, Mercer County. The judge was going through, and when the tenant didn't show up, he said default and then moved on. So that's obviously the best case scenario and the fastest case scenario. So just an FYI, DCA rental assistance, as you can see, it's raining money, $750 million. And I couldn't help myself. I just want to make sure everyone knows that's taxpayer dollars. So if you have a tenant come up to you and just say, you know what, I want to thank you for helping to subsidize my tenancy, you know, just say you're welcome, because it's your money and mine that's helping them out so that they can not pay their rent. Okay, so the first step, I'm going to do a couple slides on rental assistance. So the first step, and you probably already know this already, but the first step is the pre-application on the DCA website. That's the link. The landlord can do this on the tenant's behalf. DCA has been very clear. Filing once for the pre-application is sufficient. The tenant's name is then going to be in the hopper for the lottery until they're selected or the money runs out, which, based on the previous slide of $750 million, is not going to be anytime soon. So only do it once. And number two, tenants selected. And after the tenants are selected, then their eligibility is reviewed. These are the criteria that are going to be used by DCA to determine whether the person is eligible for rental assistance. I'm not going to read the slide. Obviously, you can read the slide, but just a reminder, again, we're only talking about rent that will be covered during the covered period. So that's starting March 13th of 2020. And be very careful on this, because if you're asked for documents, we have seen some cases where there's some shady stuff going on. Like, you know, I'm applying for my mother, it's my uncle, he's in the hospital. So, I mean, if you see names that don't match up, or DCA calls and says, hey, we have $40,000 here for Bill Smith in apartment 6A, and you don't have apartment 6A, nor do you have a Bill Smith, as tempting as it is to get 40 grand, you do not want to be a party to a fraud. This is just to give you an idea as to what the income limits are for various counties. I'm not going to read, again, I'm not going to read through all these, but I'll leave it on for 5 or 10 seconds so that you can see your particular county if it's on there. These are the rental caps. So if your family size makes more than the amount listed in your column, then you're not going to be eligible for rental assistance.
They're pretty similar.
Yeah, and I think I heard earlier you guys are going to put stuff on our website, and maybe I have no idea how to do it, but I'm sure someone at our office knows how to put this PowerPoint on there if you're interested in seeing.
Yeah, send it over to Marley. We'll get it up there.
Okay, so steps 3 and 4, tenant and landlord submit required documents to DCA. So if the tenant's been approved, they meet all the criteria, their income's okay, then they're going to ask you for documents. Now, this is an interesting question, quandary, if you will. So New Jersey's law against discrimination prohibits discrimination based upon the source of lawful income. So in other words, unlike Pennsylvania, you must accept rental assistance if the tenant qualifies for rental assistance. However, the new law says that in order to receive a DCA rental assistance funds, you are waiving the late fees for the entire assistance period. So if you are, they're going to pay 12 months worth of rent. You got $100 a month in late fees. That's $1,200 that you're supposed to just eat in order to accept this money. I asked this question of the DCA people at one of our seminars, and the answer was, look, the landlord's going to be so glad to get their money. They're not going to care about the late fees, which I don't think is an answer. I've been thinking about this, and the workaround that I was thinking of maybe trying just to see what happens is when you get the application, when you get the request, you get the form to fill out. I think I'd be interested in seeing what happens if we take a Sharpie and just cross out the part that says the landlord agrees to waive the late fees. Because the quandary here is, if we say, no, we're not waiving the late fees, so we're not accepting the money, the tenant's going to run to legal services and they're going to file a discrimination case with the New Jersey Department of Civil Rights saying we're discriminating on their income. And our argument would be, we're not discriminating on the income, we just don't want to eat this $1,200 in late fees. So I'm not going to dwell on this, but it's an interesting question. And I'm looking for a guinea pig when the time comes. Somebody who likes me enough to work with me for a day or two on this and, is in for the long haul, because this might be fun. Okay. So I tell you guys this all the time, but I'm reminding you again, if the tenant has a balance, do not offer them a lease renewal, because that's a waiver. Get it? It's a waiver. The kid's waving. He's nobody gets it.
I got it.
Well, everybody's on mute. I'm sure you're all laughing. I just can't hear. Anyway, the case is
That's
Montgomery
as bad
Gateway.
as Paul's jokes, Matt. I mean, you're getting pretty bad here.
Well, good. I'm getting there. Montgomery Gateway versus Herrera is the case. I've talked about this at pretty much every one of these. You don't have to give them a lease renewal in New Jersey. You can't throw them out because their lease ends. But my advice is do nothing, because if you do nothing, then they're going to end up being a month-to-month tenant under the same terms as the last written lease. And you're not waiving your right to evict them for any of the money that's owed because you didn't offer them a new lease renewal. Orders to show cause are still a viable option. We've been doing some of these for you guys. They are expensive. They're $1,000. Some of you who have done them know this. This is a process where we file a normal complaint. And by the way, the notice requirements still need to be satisfied before we file the complaint. We file the complaint, and then after we get a docket number, then I follow it up with an application called an order to show cause, telling the court that we are arguing that this is an emergency. It needs to be heard right away. The person needs to be locked out right away. As those of you who have talked to me about orders to show cause know, I give you a very honest evaluation because I don't want to see you spending that kind of money if you're not going to get the results that you want. We've done 25 or 30 of these, and we've won all of the ones that we've gotten hearings on, except for one. I don't want to talk about it. I hadn't lost a case, if I may. I hadn't lost a case in New Jersey for like 2 years. I'm still recovering. Anyway, so the considerations for order to show cause, is it really an emergency, or are you just fed up with this tenant and you hate them and you want them out? Those are two different things. So I'm happy to have a conversation with you about the chances of success on an order to show cause. Remember, once you issue a notice, like I said, the statutory notice requirements still have to be satisfied. Do not accept any funds after a notice to quit is issued. That also is a waiver. As you can see, it's a smaller waiver, but it is a waiver. And the case on that is Jasontown Apartments versus Lynch. Make a habit of telling us right away the tenant on whom we're filing receives any kind of subsidy. If they got a voucher, if it's project-based, low-income housing tax credit, because that means the notices have got to be copied to the housing agency. It also means that we may have to give them additional notices that aren't required by state law, but are required by federal law. Look for a notice from DCA about this stuff, and they are going to mandate that you post this notice in your multifamily properties. Obviously, don't ask for it, but if DCA sends you a flyer about this, all this, tenants' rights and rental assistance and all that, and ask you to put it up, you're going to have to put it up. Another part of the new law, landlords cannot report the non-payment or late payment of rent during the covered period to any credit reporting agency, rental reporting agency, or to any other landlords. There are penalties for this. It's going to be enforced by the Attorney General's office. So you can't tell anybody that your tenant is a deadbeat.
Matt, can I ask you a question on that before you move on? If
Yes.
you sue a tenant in small claims court and you get a judgment, are you not allowed to have your collection agency collect on that judgment?
You can have the collection agency collect on the judgment. It's still a money judgment. You just can't report it. You can't report it to credit reporting agencies, or when the new landlord calls and says, how about Susie Q? She wants to move in. Your answer should be, I'm not able to really say anything about Susie Q.
Okay.
You can't say, yeah, she's great when she paid rent 3 years ago.
Okay.
Just a reminder, I know you're frustrated. I'm frustrated also, but self-help evictions are a no-no. You're looking at possible criminal penalties. It's a disorderly persons offense. Also triple damages on personal property, double damages on the security deposit. So don't even think about it. If you have any questions, you can give us a call at the office. I will be happy to answer them. Jackie and Di are also very well versed in New Jersey law. And so any questions that you might have, feel free to give us a call at the office, and we will certainly be willing to answer your questions. Hope if I don't know the answer, I will make one up.
You look like you had a little more hair in that picture, Matt.
Thank you for noticing. So I have 6 minutes to answer questions, and then I'm actually out in Pittsburgh getting ready to head to court to do a case out here, and I got to leave at about 1:45. So
Okay, couple real quick, okay? When you said to not renew the lease, and it goes to month, are they allowed to charge a month-to-month rate?
I get this question a lot. The answer is no. And the reason is because this is a public policy issue. So the public policy behind month-to-month fees is for a situation where you're the landlord and you say, okay, well, your lease is up here. We'd like you to sign a new lease. And the tenant says, go pound sand. I'm not signing your lease. That gives you a mechanism to penalize them, to kind of push them into signing a lease. A judge is not going to enforce these month-to-month fees if you are the one creating the situation, because it would be against public policy. If you're the ones, the tenant's saying, hey, great, I'll sign a new lease, and you're saying, I'm not giving you a lease, and because I'm not giving you a new lease, I'm charging you month-to-month fees. You can't create a self-fulfilling prophecy. So I think the likelihood of enforceability is about 0.
Okay. If we do not offer a renewal, that means we can't increase the rent or anything, right? Everything has to be the same.
That is correct. But the amount of rent increase that you would not be getting is going to be far outweighed by the amount of money that you're going to be waiving as far as the eviction complaint goes. Because remember,
Besides, you're doing this because they're not paying you. So what's the point of increasing the rent? You're just
That's
increasing
true.
the amount you're not getting.
I mean, if the goal is to get them out, you want the money amount to be as large as possible so that it's insurmountable for them. So, if you give them a new lease and raise their rent, then you're cutting yourself, you're creating a flashpoint, and you're not going to be able to evict them for the non-payment before that.
Okay. Can we report a balance to an agency if they vacate, skip out during the restricted period? That only applies to the people who have those certifications filed, correct? You can still report.
You know what? That's a great question. I don't know if they have to have the certification or if that's just a blanket protection. I thought that I had thought of every question, but I hadn't thought of that question.
Okay. So to be continued.
Yes.
We'll find that out. Okay. This is all very new, guys. This all came down on August 4th. And some of these parts even later, and even the courts are grappling with how to deal with all of this right now. We don't even know how, up until a day or two ago, how the tenants were to get the form to certify. So, when we first started to put this together, Matt still had to try and figure that all out. So the courts didn't even know. So we're learning as we go here. So that's a great question. We'll let you know. But I would think that in practicality that you should be able to submit things to your collection agency if it wasn't a covered person, but we'll have to figure it out.
I mean, I definitely think you can submit it to collections. I don't know that there's any prohibition on that. I just don't know that you can proactively report it
to like Experian or TransUnion.
Correct.
Or whatever. Okay. Yeah, but a lot of times the collection agencies go ahead and do that. So you got to be careful. So, okay, that is it. Most of these people were commenting LOL and haha. So I think people liked your presentation.
Well, I'm glad. Thank you, everyone. I will stay employed probably for at least another couple days.
Matthew, good luck in court. Go ahead and jump off while we wrap things
Okay.
up.
See you, everybody.
Bye, Matt. Matthew Brady, ladies and gentlemen.